The fact that the court has agreed to hear the case is very significant. Often the court gets involved when lower courts come to different opinions about the same legal question, but that's not the case here. Lower courts have routinely upheld the use of race in college admissions based on Supreme Court precedents. The Supreme Court's interest in taking this case is a strong suggestion that there may be a majority on the court for overturning those precedents and limiting, if not eliminating, the use of race in college admissions. Under Supreme Court rulings that date back several decades, race can be considered as one of among many factors in college admissions, but it can only be considered for the purpose of ensuring that there's a diverse class of students on campus. The Supreme Court has previously held that quotas are unconstitutional, so it can't be used in any sense in that way, but it can be used to promote diversity on campus. The challenge is that by considering race at all, colleges and universities are actually discriminating against other people. In the cases that the court agreed to hear, it's primarily claims of Asian American applicants that they're being discriminated against by the university's consideration of race. In both cases, lower courts in North Carolina and in Massachusetts found that those claims were not substantiated, and they sided with the universities. But the Supreme Court is going to review that, and with a more conservative court than the one that upheld the use of an affirmative action plan in Texas as recently as 2016, that ruling is under threat at the Supreme Court now.